In this video, I'm going to explain, is the SAVE Act constitutional? I'm Terrence W. Moore, the Bulldog lawyer. I want to tell you about a woman named Ruth. She's 73 years old. She lives in Mississippi. She was born at home. No hospital, no birth certificate. She's never owned a car. She doesn't have a passport. And she has voted in every single election since 1972. Under the SAVE Act, Ruth can't register to vote. No photo ID, no registration, no vote. Now, the supporters of this bill will say it's not a real problem. Everybody has a photo ID, right? No big deal. Here's the big deal. 21 million eligible American voters don't have a government-issued photo ID. And those people aren't spread evenly across the population. They're disproportionately elderly, poor, rural, people who don't drive, people who can't easily take half a day off of work to stand at the DMV. Getting a photo ID without a birth certificate, without a car, without ready cash, that's not a quick errand. It's a multiple-step obstacle course. And the people who designed this law know exactly who gets stopped at the finish line. Now here's what you need to understand, because this is where the legal argument matters, and I don't think most people think about it this way. The Constitution does not give Congress the power to set voter qualifications. Article 1, the 17th Amendment. Article 2, they all say the same thing in different ways. The authority to set your qualifications belongs to the states. Congress has a very specific role in elections. The Elections Clause gives Congress power over the time, place, and manner. That means procedures, logistics, scheduling. It does not mean eligibility. Requiring proof of citizenship to register to vote is not a procedural rule. It is a qualification rule. And under the Constitution, that power sits with the states, not with Washington, D.C. When Congress reaches for a power the Constitution reserved for the state, that's called overreach. Doesn't matter which party does it, overreach is overreach. Both parties here know the real math. Studies show that voter ID laws reduce Democratic turnout by 3 to 5%. In a purple state, where elections are decided by 1 or 2 points, that's a structural decisive disadvantage. Republicans say this is about stopping fraud. Democrats say it's about voter suppression. Both of them are arguing for their own position, and neither of them is arguing from the Constitution. Here's what the Constitution actually says about this fight. It does not belong to Washington, D.C. So what do you do about it? 2 things. First, if you oppose the SAVE Act, don't call your congressman, call your governor, your state attorney general, your state legislature. They have the authority to challenge this federal overreach. Because voter qualifications are a state power under the Constitution, state level action is where you actually have leverage. The Constitution put the power there on purpose. Use it. Second, stop letting both parties frame this as a partisan fight. The moment you accept that framing, you've already lost the rule of law argument. This is not about Republicans and Democrats. It's about whether the federal government gets to decide who votes. And the Constitution's answer to that question is clear and resounding: no. Ruth isn't waiting for the appellate courts to sort this out. The election will come before the litigation ends. And that's exactly why the framers put this power in the hands of the states. They understood what happens when a federal government controls who gets to vote. The party in power picks its own electorate. That's not a republic. It is something else entirely. I've written a full breakdown of this, the constitutional argument, the disenfranchisement numbers, and the political math both parties are running. The link is in the description. Read it. Share it. And if you want to talk about how the rule of law applies to your business, your partnership, your deal, your exit, you know where to find me. I'm Terrence W. Moore, the Bulldog lawyer. I'll see you in the next one.